Hello viewers, and welcome to part 3 of our video presentation entitled Estate Settlement in Connecticut. My name is Richard Land. I'm an attorney and a member of a Danbury, Connecticut law firm known as Chipman, Mizuko, Emerson. In parts 1 and 2 of this presentation, we covered the job description of the executor and the administrator of an estate, including many of the issues the executor and administrator must face. Now, pretend for a moment that you're an executor of a will. You've gone through all the steps we discussed in parts 1 and 2 of this presentation. You've filed the probate application with the probate court, and you got yourself appointed as executor. You paid the decedent's debts and took care of the tax obligations. You sold the estate assets to raise the cash you needed to satisfy the obligations, and you think that you're pretty much finished with your job, and you want to make final distributions to the beneficiaries of the will. At this time, you, as an executor, are in a pretty uncomfortable spot. You think you're done, and you think you've done a good job, but what if any beneficiary disagrees? Do you really want to make final distributions only to find out that a beneficiary thinks you should have done something differently and is making a claim against you? No, typically you would want to know with certainty that the interested parties are satisfied with the job you've done, including the compensation that you claim. You want finality before you distribute. Don't forget what estate settlement is. It is the process of resolving conclusively the rights of interested parties in the estate, and you want that final resolution before you distribute. The question is, how do you get that type of finality? The answer is that you get it by disclosing to the beneficiaries what you've done. That's an accounting, and you ask the beneficiaries and the probate court to approve it. In some states, a full accounting in the probate court is not necessary, but even in those states, an executor is probably making a mistake if he makes final distributions before accounting to the beneficiaries and asking for their approval. In Connecticut, a final account in probate court is required. The whole point of the accounting, keep in mind, is for you, as executor, to disclose what you've done and then to ask the court and beneficiaries to approve it. Then you can make your final distributions. When you account, you're basically disclosing how you handled each and every asset listed in the inventory. You're disclosing what asset you sold to raise cash to pay debts and expenses, and whether it was sold at a gain or a loss. You're disclosing all the income earned by each asset, and all the debts, expenses, and taxes you paid. You're disclosing the fee that you claim for your services, and you're reporting on the assets that are on hand for distribution, and you're asking the court to approve your plan for distribution. It sounds simple, but it can be a challenging job, especially if the executor fails to keep good records or commingles his own assets with estate assets. Full accounts can be lengthy, and depending on the estate, can be many pages. The rules now allow executors to file accounts that are more of a summary of the full account. But that does not mean the executor is relieved from the duty to account for every asset and every payment. It merely means that the accounts filed in the court need not disclose every detail, because what is filed will be a summary of the details, a condensed version of the full account. It will still be necessary for the executor to be able to offer the detail to a beneficiary who requests it. As attorneys who represent beneficiaries, it's not unusual for us to advise our clients, the beneficiaries, to request the details before approving an account instead of relying on the summary. Let's talk about some of the more significant expenses of estate settlement. First, let's talk about the fees of the probate court. You can see here how the probate court fees are determined. Usually the fee is based on the size of the estate for estate tax purposes. If an estate has a value of $500,000, the probate court fee is $1,865. Before July 1, 2015, the fee was set at 0.25% of the excess over $500,000. Effective July 1, 2015, that was changed so that after the estate reaches $2 million, the fee on the portion above $2 million is 0.5%. So here you see that the fee on an estate with a value of $2 million is $5,615 plus 1/2 of 1% of the excess over $2 million. For a period of 1 year, there was no cap on the probate court fee. Effective July 1, 2016, when the size of the estate gets to $8,877,000, the probate court fee is capped at $40,000. The $40,000 cap was effective July 1, 2016. There is some relief when the decedent is married and assets pass to the surviving spouse. When assets pass to a surviving spouse, the value of the assets passing to the spouse is reduced by 1/2 when determining the probate court fee, so there is a reduction for assets that pass to a spouse. Keep in mind that avoiding probate through use of a revocable trust, joint ownership, or pay on death or transfer on death accounts will not avoid probate court fees. That's because the probate court fees are based on the size of the estate for estate tax purposes, not just the probate estate. So the estate for this purpose includes not just the probate assets, but also all the non-probate assets that we talked about earlier in part 1 of this presentation. Let's turn our attention to the executor's fees. If you listen to the first 2 parts of this presentation, you have a pretty good idea of what an executor is supposed to do and the risks the executor is exposed to. It can be a lot of work, and the executor is entitled to reasonable compensation. That's the standard in Connecticut, reasonable compensation, unlike New York, which has a fee schedule set by statute. It will always depend on the specific facts, but there are some objective benchmarks we can point to when advising our executor clients. First, we advise our clients to keep a log of the time they spend performing their duties with a description of the activity. The time and effort involved are always factors. Also, quite a few years ago, we collected all the information we could on what local banks and trust companies would charge for their services as an executor. This table is representative of what we found at the time. The numbers you see here should be considered ballpark numbers, representative, but not really the fees of any particular bank or trust company. From the information we can gather today, we believe that this continues to be fairly representative. So a bank or trust company might charge in the ballpark of $20,000 to settle an estate which has a value of $500,000. As a practical matter, however, it would probably be hard to get a bank or trust company interested in settling an estate of that size. A bank's fee for an estate with a value of $1,500,000 might be in the $50,000 ballpark. Banks and trust companies are likely to provide many of the accounting, investment, and tax services in-house, while an individual executor may need to have additional help to provide such services, so the individual's fee might be less. Other benchmarks we look to are statistics that are frequently referred to, presumably compiled by the Probate Court Administrator's Office. We understand that such statistics for Connecticut estates indicate that the average aggregate value of executor, attorney, and accountant's fees range from 4% to 6% of the value of the estate. The probate courts seem to give these averages some weight when scrutinizing fees as part of the final account. The fees for the attorney or law firm will be another significant expense. Fee practices vary among attorneys. Some will state their fee as a percentage of the value of the estate. If the executor is a bank or trust company, which does much of the work in-house, while the attorney may do less, the percentage may be lower. If the executor is an individual who relies on the attorney to do much of the work of an executor, including accounting and tax work, as well as the normal legal services, the prevailing rate appears to be in the 3% range. Some attorneys will charge strictly on the basis of time. Often the attorney will be assisted by paralegals whose hourly rates are quite a bit lower than the hourly rates charged by attorneys. Also, hourly rates can be quite different depending on location. The hourly rates of attorneys and paralegals in southern Fairfield County, for example, can be quite a bit higher than the hourly rates prevailing in eastern Connecticut. Finally, some attorneys will try to estimate the time it will take to complete the matter and offer a fixed fee on that basis. That's the end of Part 3 and the end of this presentation of estate settlement in Connecticut. We hope it is helpful. At this point, it would be natural for you to go on to view our video on trust administration in Connecticut. It picks up where this estate settlement presentation leaves off. If you have any questions, we would be pleased to have the opportunity to answer them. Thank you for viewing.